Hello, everyone, and welcome back to Civil Liberties. This is the second PowerPoint and video on this topic. When we talk about civil liberties, one thing we need to talk about is the First Amendment, right? That's one of our fundamental rights, the First Amendment. Freedom of religion, that says Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. So the first part of the First Amendment, the freedom of religion, has two parts within it. All right, Congress shall make no law respecting the establishment of religion or prohibiting the free exercise thereof, which is interesting, right? The free exercise clause states that Congress shall make no law prohibiting the free exercise of religion. We can worship, pray, or whatever to whatever deity we wish. All right, and the federal government can't do anything about it. All right, so the free exercise clause, the second part of the freedom of religion amendment, part of the amendment is that states that Congress shall make no law prohibiting the free exercise of religion. We have a right to worship as we please. All right. There are a few exceptions to this, right? Because everything has an exception, right? So Mormons can practice however they want. But one of the things with Mormons is they can have more than one wife. But we say no. A man cannot have more than one wife, even if polygamy is thought desirable on religious grounds. All right, so there are exceptions to the free exercise clause. Another one is compulsory vaccines. You can be required to get vaccinated, even if it is against your religion. All right, so like everything within the Constitution, there are the rules, and then there are the exceptions to the rules regarding the same. The free exercise clause, other exceptions are, you got to think about it. Does the free exercise clause of religion apply to Title IX? All right, Title IX. That says Title VI, but it should be Title IX. It should be next there. Title IX. All right, which is interesting. Some schools have said no. Title IX says there needs to be equality in both high school and college extracurricular activities. Some religious schools say they don't have to follow Title IX. They don't have to have equality between the sexes when it comes to extracurricular activities at high school or colleges. And again, that's Title IX, 1X, not 1.5. All right, so the First Amendment, freedom of religion, the Establishment Clause, right, states that Congress shall make no law respecting an establishment of a religion, no national religion. This creates the wall of separation between church and state. Okay, no national religion. Per the First Amendment, a wall between church and state. That's the separation. Okay. The Establishment Clause says no prayers in public schools, no prayers at public school graduations. All right. Students may not lead prayer before a football game at a public school. All right. So you can't establish or promote a religion also. But the interesting thing is the Establishment Clause is the courts have also said that local legislative sessions may begin with a prayer. So schools can't begin with a prayer, but a local legislative session can. And also, you cannot prohibit a high school football coach from praying on the football field after a game. So, it's interesting how these things pan out. No school prayer, but no praying before a game. But, after a game, a coach can't pray on the football field if he or she feels it's appropriate. All right. The civil rights as applied to crime and due process. There's this thing called the exclusionary rule. Right, you read about the exclusionary rule in the book. Evidence gathered in violation of the Constitution cannot be used in a trial. Right, that's the exclusionary rule. Evidence gathered in violation of the Constitution cannot be used in a trial. This is the fruit of the poisonous tree doctrine. All right, the fruit of the poisonous tree doctrine. If the tree is poison, so is the fruit. Okay. The case is Mapp versus Ohio for anybody taking notes on this. All right, so evidence gathered in violation of the Constitution cannot be used at trial. All right, there has been a relaxing of this exclusionary rule post 9/11. Courts have tried to modify but retain the exclusionary rule over the years. They have modified it, especially post 9/11, where we were scared, right? So we were willing to give up a little of our freedom in name of safety. All right. The good faith exceptions, of course, there's always an exception to the exclusionary rule. And gathering evidence sufficiently minor still may be used at trial. All right, even if it's a minor defect, we're not going to say everything's gone. And the public safety exception. Police can question a non-Mirandized suspect if there is an urgent concern for public safety. Right? So these are some of the exceptions to the exclusionary rule. And also another one is inevitable discovery. All right? The police can use evidence that would have inevitably been discovered. All right? So even though you did it wrong, well, it would have eventually been discovered anyways. So it's not poison, fruit of the poisonous tree. Right? Because we would have found it anyways. All right? So inevitable discovery exception is an exception to the exclusionary rule. All right, the Fourth Amendment, search and seizure. Right, search and seizure. The Fourth Amendment says you have a right against unreasonable search and seizures. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause. Great amendment. All right, the Fourth Amendment, search warrant. Basically is an order from a judge authorizing the search of a place. Right? So if you need a search warrant, that comes from a judicial body, that comes from a magistrate, a judge, and they will issue you a search warrant as long as there is probable cause to do so. The order must describe what is to be searched and seized, and the judge can also issue, if there's probable cause, that a crime has been committed and that the evidence can be found at a certain location. Right? The judge can only issue if there is probable cause that a crime has been committed or will be committed and that evidence can be found at a certain location. All right, you got to be real specific in your warrant. This is the house. This is, we're going to find it here, that kind of thing. All right, search warrant is based on, again, on probable cause. Probable cause is a reasonable cause for issuing a search warrant or making an arrest. It's more than just mere suspicion. You got to have a little bit more. I think, no, it's got to be more than that. Okay, it's got to be, I think, and I saw. I think in somebody told me that it's going to be there. Okay, without a search warrant, you can, if it's incidental to a lawful arrest, so you can search somebody, pat them down if they're arrested, incidental to a lawful arrest. And that leads to the question, how can an individual be arrested? Well, two ways. If a judge issues an arrest warrant, based again on probable cause, or if a crime has been committed in the presence of a police officer. Okay? All right. And the last thing, Miranda warning. Miranda, you have a right to remain silent. Anything you say can and will be used against you in a court of law, right? You need to be Mirandized. The police, once arresting you, have to give you your Miranda warnings. They have to tell you you have a right to remain silent. And I encourage you all to remain silent until you speak to an attorney, all right? Because the attorney will guide you on what you should and what you should not say. All right, so the Miranda warning, the Miranda case says you have a right to remain silent. Anything will be used against you. If you cannot afford an attorney, one will be provided for you. They have to make sure that you understood your rights and then ask if you'll speak to the cop. Okay? All right, so that's it. Thank you very much. We'll talk to you next week.